Welcome back. In this next section, we'll delve into discussing the tools used in this process, the Giglio Letter and the Giglio Questionnaire. Then we'll examine whether an officer has the right to a hearing to clear their name. What is a Giglio Letter? A Giglio Letter is a formal disclosure document issued under the obligations established by the Giglio decision. Its primary purpose is to inform the defense of any evidence or information that could undermine the credibility of a government witness. This includes details such as undisclosed promises, biases, or prior instances of misconduct that may call into question the reliability of the witness's testimony. In many cases, this letter is part of the prosecution's duty to provide the defense with all Giglio material, ensuring that any factor which might be used to impeach the witness's trustworthiness is shared before trial. In some contexts, a Giglio letter might also alert the officer in question, offering them the opportunity to address or contest the findings. What is a Giglio Questionnaire? A Giglio Questionnaire is a structured tool used by law enforcement agencies or prosecutors to gather detailed information about an officer's past conduct and potential credibility issues. Its purpose is to systematically identify any instances, such as prior errors, misconduct, or other problematic behaviors that could later be deemed Giglio material and undermine the officer's reliability as a witness in court. Let's take a look at some of the key points of the questionnaire. Key points include systematic disclosure. The questionnaire is designed to prompt officers to disclose any information that might impact their credibility, ensuring that no relevant details are overlooked. Assessment of credibility. It helps determine whether past behaviors, mistakes, or any undisclosed issues may compromise an officer's testimony, aligning with the obligations set forth by the Giglio ruling. Preventative measures. By identifying potential issues early on, the questionnaire aids in addressing concerns before they escalate into larger legal or reputational problems. In essence, the Giglio Questionnaire serves as an important preventive and evaluative instrument in maintaining the integrity of courtroom testimony by ensuring that all relevant information about an officer's background is disclosed and reviewed. So, what types of questions may be in the questionnaire? Here are a few questions on the Salt Lake County, Utah District Attorney's Office, Brady, Giglio Questionnaire. 1. Are you aware of any allegations or findings that reflect on your truthfulness or bias? 2. Are you aware of any past complaints, investigations, or disciplinary actions against you? 3. As a police officer, have you ever been disciplined or admonished for conduct that involved acts of dishonesty or deception? 4. Are you the subject of a pending investigation that involves allegations of dishonesty, deceit, or bias? Questions like these and others are crafted to unearth details that could compromise an officer's reliability as a witness. While specific questions may vary by department or jurisdiction, the types of queries typically address situations involving dishonesty, prior misconduct, or any actions that might impair an officer's trustworthiness. No matter the jurisdiction, you can most likely count on questions from these common categories: honesty and integrity, criminal or unethical behavior, substance abuse or dependency, use of force or misconduct, bias or prejudice, prior testimonies and court appearances, and legal and ethical based. Now that we've explored the Giglio Letter and the Giglio Questionnaire in documenting credibility issues, let's transition to an equally important question. Does an officer who receives a Giglio Letter have a right to a name-clearing hearing? For the next few moments, let's examine the legal and procedural aspects of this issue, discussing the officer's rights, potential remedies, and the broader implications for fairness in the disciplinary process. For this, we turn in part to a June 2023 article written by Jeff Welty for the North Carolina Criminal Law blog at the University of North Carolina School of Government. An officer who is fired will sometimes have a right to a name-clearing hearing, at which the officer may supply evidence contradicting negative information about the officer's honesty or integrity that the agency released in connection with the officer's termination. But is an officer who is fired in connection with a Giglio letter entitled to such a hearing? Under most circumstances, the answer to that question is no. Officers are not entitled to a name-clearing hearing from the district attorney. A name-clearing hearing is only available when a stigmatizing statement is made in connection with an officer's termination or demotion. A district attorney has no authority to fire or demote a law enforcement officer. Of course, a law enforcement agency may decide to fire an officer who receives a Giglio notification, but that's up to the agency. The agency is free to disagree with the district attorney's assessment of the officer and to keep the officer employed, perhaps in an administrative role or in a position that is unlikely to require the officer to testify. In any event, a prosecutor's decision not to offer a name-clearing hearing in connection with a Giglio letter is almost certainly immune from legal challenge. It may be protected by absolute immunity on the theory that Giglio-related decisions are decisions about which witnesses to call, which is an essentially prosecutorial function. All of this means district attorneys have considerable and largely unreviewable authority in connection with Giglio determinations. When a prosecutor creates a list of officers deemed untrustworthy as witnesses, a practice resembling an impromptu Giglio list, the rights of the affected officers become a matter of significant legal and administrative debate. Here are some key points to consider. Prosecutorial discretion versus due process. Prosecutors generally have broad discretion over which witnesses they call to testify. This means that, under normal circumstances, a prosecutor can decide not to use an officer's testimony if concerns about credibility exist. However, when an officer's name is placed on such a list and it has tangible consequences on their career or reputation, due process considerations may come into play. In certain contexts, the officer might argue that they have a right to challenge this designation. Right to a hearing. The right to a formal hearing to clear one's name is not automatically guaranteed in the realm of prosecutorial decisions. As mentioned earlier, these decisions are often considered part of the discretionary process of trial preparation. However, if the exclusion from testifying leads to significant employment or reputational harm, an officer may be entitled to some form of administrative review or a hearing under departmental policies or civil service rules. This hearing would allow the officer to present evidence, respond to the allegations, and potentially have the decision reviewed by an impartial panel. Transparency and accountability. A key issue is whether the officer was given a clear explanation for why their credibility was in question and whether they were provided an opportunity to address those concerns before being barred from testifying. If the process lacks transparency, it raises questions about fairness and could form the basis for a legal or administrative challenge. Contextual variability. The rights of these officers can vary significantly depending on the jurisdiction, the policies of the employing agency, and the specifics of the case. Some departments have established procedures for officers to contest negative findings, while in other settings, the prosecutor's decision might stand with little recourse. Let's watch two videos that shed light on a controversial action initiated by St. Louis Circuit Attorney Kim Gardner in the fall of 2018. At that time, she compiled a list of about 30 officers deemed untrustworthy, alleging issues with their credibility. However, what makes this situation particularly opaque is that the identities of these officers, the specific actions that led to their being labeled as untrustworthy, and even the details on how some of them may have regained trust and been removed from the list, remain shrouded in secrecy. As you watch, consider the balance between prosecutorial discretion and the rights of officers, and reflect on the importance of transparency in maintaining public trust. Let's begin with the first video.
Circuit Attorney Kim Gardner announcing today that she will no longer accept criminal cases from certain police officers.
Now, the Missouri Attorney General fears this means even serious criminals will simply go free. Fox 2's Andy Banker has the backlash swirling around Gardner tonight.
We're outside Gardner's office. She has yet to say why she has created the so-called exclusion list, but we have confirmed it has been delivered to the police department and that the names of 28 police officers are on that list. This means Gardner will refuse to prosecute any cases if any of these 28 officers happens to be critical to the investigation. Gardner also has yet to say who is on the list or give specifics as to why. The leader of the St. Louis Police Officers Association says the 28 officers already have dozens, if not hundreds, of cases before the court, and that Gardner owes it to crime victims to go case by case and not to work from some kind of list. He has a team of attorneys reviewing possible legal options.
2.5% of our department. I would say that overnight last night, crime increased by 2.5% because Kim Gardner decided not to do her job 2.5% of the time.
I am deeply concerned that this action will result in criminals going free, being unaccountable, and vulnerable communities not getting the protections that they deserve. So I look forward to answers from the Circuit Attorney's Office, and we're monitoring this very closely.
So far, neither Gardner nor Police Chief John Hayden is commenting on the case or taking any questions from reporters. This is what we have from Gardner so far, a statement which reads in part, "To do our jobs properly and legally, we must have confidence in the accuracy and honesty of the oral and written reports of police officers. Any break in trust must be approached with deep concern. I'm confident the SLMPD leadership share in our commitment to ensure the integrity of every single case police bring to our office for charges." A statement in response from the police department reads in part, "We are seeking legal guidance on how this affects the police division. We have also taken steps to notify each of the involved employees. We are considering how best to proceed and what, if any, actions to take." As of now, we're told these 28 officers are still on the street fighting crimes in St. Louis.
Follow up to a story we first brought you last night. Nearly 24 St. Louis police officers suspected of sharing violent, racist, and anti-Muslim Facebook posts have been put on an exclusion list by the city's top prosecutor.
Fox 2's Andy Banker shows us what that means.
Circuit Attorney Kim Gardner says these officers can no longer come to her office seeking charges against criminal suspects. If they do, those cases will be refused. Gardner says she has added 22 more St. Louis officers to her so-called exclusion list. 7 are permanently banned from the Warren office. Criminal cases in which they are essential witnesses will be refused. 15 of the 22 officers will be under review to be reinstated from the list. This comes after a national study called the Plain View Project revealed the officers shared controversial Facebook posts between 2013 and 2017. The city's public safety director says the 3 most egregious offenders have been reassigned to desk duty. A police internal affairs investigation could still possibly result in termination. The head of the Police Officers Association says that's all part of due process, but he says Gardner's exclusion list is an attempt to distract from other controversies surrounding her office, like the recent arrest of her former private investigator in the Eric Greitens case, William Tisby, on perjury and evidence tampering charges.
We're witnessing the final days of an inept prosecutor's reign of terror. Hopefully the next prosecutor will have the sense not to do things that make it easier to be a criminal and harder to be a cop.
That does not mean that the criminals will not be prosecuted. What it simply means is that because this individual has offended the prosecutor's office, that individual does not go to the prosecutor's office and present their application for a warrant. Perhaps their sergeant now has to go over and present the application for warrant, or their partner will go over and present the application for warrant. It doesn't mean that the case goes away and the defendant goes free.
Now, this would make nearly 60 members of the close to 1,100 member St. Louis Police Department on the exclusion list, though Edwards says a number of the officers are no longer police officers in the city of St. Louis, and he says he knows of no case that was thrown out solely because of one of the officers on the list. But should that come to pass, Gardner says, so be it. The bias shown in these Facebook posts is so egregious that any testimony these officers would give in court would be untrustworthy.
This brings us to the end of the section. To recap, We began by defining the Giglio Letter, a crucial disclosure tool that ensures any evidence undermining a witness's credibility is shared with the defense. We then explored the Giglio Questionnaire, reviewing the types of questions commonly asked, such as those regarding disciplinary history, errors in testimony, and any behaviors that might compromise an officer's reliability. Finally, we examined the pressing question: is an officer on a Giglio list entitled to a hearing to clear their name? This discussion highlighted the delicate balance between maintaining courtroom integrity through prosecutorial discretion and upholding an officer's due process rights. It's clear that while transparency and accountability are vital, there must also be fair mechanisms for officers to address and potentially overturn findings that could otherwise tarnish their careers. Join us for our next section, where we cover how an agency can determine if an officer has Giglio issues, conduct that raises concerns but may not be a Giglio issue, and an agency's responsibilities when receiving a Giglio list. We hope to see you back soon.